Hello everyone, welcome to Code of Civil Procedure and the Limitation Act lectures. In this video, we will study res judicata under CPC. Res judicata is a phrase which has been evolved from a Latin maxim which stands for the thing has been judged. Res judicata pro veritate occipitur is the full Latin maxim which has over the years shrunk to mere res judicata. First, let's understand the literal meaning of res judicata. Res means subject matter. Judicata means adjust or decided. And together it means a matter adjudged. In simpler words, the thing has been judged by the court. The issue before a court has already been decided by another court and between the same parties. Hence, the court will dismiss the case as it has been decided by another court. In short, it is a bar for relitigation of such cases between the same parties. Res judicata is known to Hindu law as Purva Nyaya. Section 11 of the Code of Civil Procedure deals with the doctrine of res judicata. The section reads as follows. No court shall try any suit or issue in which the matter directly and substantially in issue has been directly and substantially in issue in a former suit between the same parties or between parties under whom they or any of them claim litigating under the same title in a court competent to try such subsequent suit or the suit in which such issue has been subsequently raised and has been heard and finally decided by such court. It embodies the rule of conclusiveness of a judgment as to the points decided either of fact or of law or of fact and the law in every subsequent suit between the same parties. Once the matter is finally decided by a competent court, no party can be permitted to reopen it in a subsequent litigation. Illustration: A sues B for damages for breach of contract. The suit is dismissed. A subsequent suit by A against B for damages for breach of the same contract is barred. Here, A's right to claim damages from B for breach of contract having been decided in the previous suit, it becomes res judicata and cannot therefore be tried in the subsequent suit. The reason being that B cannot be vexed twice for the same cause, that is, for the same breach of contract in this case. Moreover, public policy also requires that there should be an end to a litigation, and for that reason, the previous decision must be accepted as correct, lest every decision would be challenged on the ground that it was an erroneous decision and there would be no finality and the parties would be put to constant trouble, harassment, and expenses. The doctrine of res judicata is based on three Roman maxims. A. Nemo debet lis vaxari pro eadem causa, which means no man should be vexed or annoyed twice for the same cause. So, this doctrine is similar to the concept of double jeopardy, but in civil law version. B. Interest republicae ut sit finis litium, meaning thereby that it is in the interest of the state that there should be an end to a litigation. C. Res judicata pro veritate occipitur, which means a judicial decision must be accepted as correct. Thus, the doctrine of res judicata is a fundamental concept based on public policy and the private interest. Justice Das Gupta in Satyadhan Ghosal versus Deorajan Dev said that the principle of res judicata is based on the need of giving finality to the judicial decisions. Extent and the applicability of res judicata. It applies to civil suits, execution proceedings, arbitration proceedings, taxation matters, industrial adjudication, writ petitions, administrative orders, interim orders, criminal proceedings, etc. It is not every matter decided in a former suit that will operate as res judicata in a subsequent suit. To constitute a matter as res judicata under Section 11, the following conditions must be satisfied. The first condition is where the matter in issue is same in both the suits. The matter directly and substantially in issue in the subsequent suit or issue must be the same matter which was directly and substantially in issue either actually or constructively in the former suit. The meaning of the term directly and substantially in issue has been explained when we discussed res sub judice in the previous video. Directly means immediately, without any intervention, and substantially means materially or essentially. The matter in both the suits must be same either actually or constructively. We will understand it better when we discuss constructive res judicata in the next slide. The next condition is that the former suit must have been a suit between the same parties or between parties under whom they or any of them claim. The third condition is that such parties must have been litigating under the same title in the former suit. The fourth condition is that the court which decided the former suit must be a court competent to try the subsequent suit or the suit in which such issue is subsequently raised. The fifth condition is that the matter directly and substantially in issue in the subsequent suit must have been heard and finally decided by the court in the former suit. The rule of constructive res judicata is engrafted in explanation 4 to section 11 of the code. It is an artificial form of res judicata. Explanation 4 provides that any matter which might and ought to have been made ground of defense or attack in such former suit shall be deemed to have been a matter directly and substantially in issue in such suit. It provides that if a plea could have been taken by a party in a proceeding between him and his opponent, he should not be permitted to take pleas against the same party in the subsequent proceeding with reference to the same matter. Illustration to constructive res judicata. A sues B for possession of property on the basis of ownership. The suit is dismissed. A cannot thereafter claim possession of property as mortgagee as the ground ought to have been taken in the previous suit as a ground of attack, because it is opposed to the public policies on which the principle of res judicata is based. It would mean harassment and hardship to the defendant. The rule of constructive res judicata helps in raising the bar. Hence, this rule is known as the rule of constructive res judicata, which in reality is an aspect or amplification of general principles of res judicata. The test to apply section 11 is whether the second suit could have been decided by the first court. If the answer to the question is an affirmative, the decision will operate as res judicata. But if the reply is a negative, res judicata has no application. That's it for today. Thank you for watching.